And if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? Mm-hmm. You're going to be on zero tolerance. That means no mistakes on probation. All right, are you Jameldrin Wilridge? And so before we go forward, Mr. Lewis and Ms. Malfino approached about possible solutions to the issues that we have here with Mr. Wilridge is on probation. In 3 cases, there was a new offense that occurred while he was on probation, but before he went to ISF as a part of that probation. And what I want to know before I consider any type of continuation of probation is couple, I guess, number one, how do you have any idea how he did, Mr. Kitchen? I guess, and before you go forward, would you raise your right hand? You swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Any issues with regard to behavior at ISF that you were aware of?
None that I'm aware of.
Okay. When did he get back from ISF?
I'm not sure exactly. I did not receive Mr. Wilridge under my supervision until September 26th. Of last year.
Okay. And how has he done from then until he was incarcerated on this?
That went in the and he was very cordial with me. We've had cordial bit surprised by this and the other stuff that's been going on with it.
Okay. Any positive drug screens, any issues at all since you had them in September?
Mm-hmm.
Okay.
May I just ask him one question for the court?
Of course, please.
Mr. Kitchens, you brought to my attention, and I think the clerk has also sent it to Mr. Lewis and myself. His behavior in jail is less than to be desired, correct?
Yes, that's correct.
And would you characterize that as his association with those individuals who the court is very well aware are in jail, that is a different side of him than you saw while he was out on probation under the guidance and eye of the court and his family?
That's correct. Yes.
With the understanding, I'm sorry, Judge, if I may, that obviously Mr. Wilders is facing quite a bit of time from this court on a revocation. And would it be your intention, along with the court and myself, to make it clear to him that if he is given this opportunity, that if he comes back before this court, that he's not looking at maybe what he would be looking at today, but probably 3 times in advance of that amount of time?
Yes.
And do you think he is capable of and understands the seriousness of what it is he's facing?
I believe he does, yes.
From your interaction with him.
Okay. Well, Mr. Wilridge, this is tough for me. Because you've been given a couple of opportunities and this would be another opportunity. And I don't know, I don't want you back in here. I don't want you to violate. I want you to be successful. You've been on a decent path. But what you did and thought you got away with, things catch up with you. Right? And so that one's a 2 to 20 case. I could revoke you on your ag robbery and send you to prison for the rest of your life today. The rest of your life. And based on the history and what's been going on, some big fat number is probably what you deserve. And so I don't know how to be any more clear than if I give you this opportunity with what your attorney is working out with the district attorney, that Mr. Kitchen sounds like he's willing to work with you. And if I go along with this and leave you on probation and put you on a new probation, if you're back in front of me, there will be absolutely no argument about continuing probation or some low end of the punishment range. That won't be what's happening. Do you understand? Mm-hmm. You're going to be on zero tolerance. That means no mistakes on probation. You've been on it long enough now to know how to be successful or not on probation. And if you just live your life right and do what you're supposed to, that shouldn't be a problem. It's only hard if you're doing the wrong things. Does that make sense? Yes. All right, y'all can do the paperwork.
Thank you, Judge.
Thank you.
that the state has marked as exhibit number 1 before, excuse me, before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Litzkowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find this counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being here.
Thank you, Ms. Smith. Yes, sir.
All right.
See, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you a few things.
Well, he's here, so we'll.
Okay, hold on, Sarah.
You can go ahead and bring him.
What's that, Judge?
You can bring him.
More.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number 1, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What?
Over here, February 24th.
All right, so I've already made that finding. All right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity valuation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him.
Okay.
I just need a little time to get that. The state, after I get that, then we'll move forward. And
Okay.
yeah,
Do you think he can get that done in 30 days? He's already done the competency. I would think he would be able to.
when he came back from the state hospital, when he was deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from right out and did a competency,
Right.
and then billed me. But then, so I was like, it's like, hang on a second. So,
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks I'll be to him, and he'll maybe.
We'll do 30 days. And if you don't have that back, let us know right before that court date, and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay. All right. You can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane,
Yes, sir.
you've got Ahmad LeBlanc.
He's in custody.
What is this?
Ms. Malvino, Ahmad LeBlanc.
Sitting here thinking I didn't notice a nice young new probation officer.
All right, are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and on probation for possession of a controlled substance, a first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have your,
Any additions or corrections to the report?
None from defense.
only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail and this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court, Your Honor. His mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program, and another drug assessment, and we would ask that the court follow that alternative.
Ms. Malvino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwa has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the drop program.
Anything to add that's not in that updated report from probation?
No, ma'am.
So, Mr. LeBlanc, you've done so well. Better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way. You're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you You'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this was an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
So we're gonna need this though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it filed into the case.
Thank you, Your Honor.
Yes, sir.
Yeah.
See, Judge Walker, you have Paul Nelson.
Yes, ma'am.
Paul Nelson.
Yes.
Have a good day. Doing okay?
Good, how about you?
2 days in a row.
I know. Good morning. Are you Paul Nelson?
Yes, sir.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in cause number 23, DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 23, DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he has indigent. The court needs me to inquire about that. I'm happy to, but he's been incarcerated for 2.5 years and he has 0 dinero.
What are the typical court cost on a?
200 and something dollars plus this fee plus that fee. So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with the process for that, and take into consideration that he's indigent, that you relay that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back with bailiff. Yes, sir.
Have a good day.
You'll make a note for me on that, please. Mm-hmm. Mr. Lewis, you have Daryl Burnworth.
Yes.
Good morning.
Good morning, Jim.
How are you?
All right. Oh, that's it.
Good morning. Are you Daryl Burnworth?
Yes, ma'am. Burnworth.
Burnworth, and this is cause number 26 DCCR 0038. Mr. Burnworth is charged with theft of property, and that looks like it was titled a first degree felony, but it was amended for the value to be of $30,000 or more, not
Right.
300,000. Is that correct?
That's correct.
What level offense does that make it?
That makes it a 3rd degree.
Okay. Then with everyone's permission, I'm going to make that notation on the indictment. I didn't when I amended it, but that way it won't be confusing when anybody looks at it. So I'm going to take care of that. All right. So 3rd degree felony offense of theft of property. So what is the announcement?
Judge, I have been talking with Mr. Burnworth, and there are some questions that he brought to me in regards to his criminal history that went to the offer that was made by Ms. French at this time. All his history is in Louisiana, so I just need to verify some things for her.
Okay.
So if I can just get a couple of weeks, I think we'll be able to get this one resolved.
Okay. Any issues, Ms. French?
None at all, bro.
All right. We'll reset it to either 2 or 3 weeks, depending on the dockets. All right. You can go back with the bailiff. See, Mr. Lewis, you have William Miller.
Yes.
William Miller.
And this is Mr. Coleman.
Yeah, I think he's the report came back incompetent.
Correct.
Good morning.
Good morning.
Since I hadn't, my only cases got reset, so for my time to say.
Nice of you. Good morning. Are you William Miller?
Yes, ma'am.
And this is 26 DCCR 0063. Mr. Miller is charged with the offense of robbery. There was an evaluation for competency that was done by Dr. Grimsley and received that. Okay, the exam date was March 5th of 2026. The finding in that report is that Mr. Miller is currently not competent to stand trial and that inpatient competency restoration would be warranted for him to regain competency. Is there any other relevant evidence?
Overstood, Your Honor.
Yeah.
Nothing else,
With
nothing
regard to
else from the state.
competency.
No, Your Honor.
Nothing from the defense.
Then based on that and based on the report by Dr. Grimsley, I am going to find that Mr. Miller is currently not competent to stand trial. Order that inpatient restoration is warranted for competency restoration and that he be sent to the appropriate facility for a period of not to exceed 120 days from the day you get to that facility. So Mr. Miller, you'll get sent to a hospital.
Thank you.
And they'll get you taken care of so you can understand everything better, and then we'll get you back to take care of your case. Okay? You can go back with the
Oh,
baby.
wait, thanks, yeah.
Yes. Jamaldrin Willridge.
Let we hold on that one, I think.
Okay.
That's
Sure. And maybe when the court has a couple minutes, maybe I'll just speak to you.
We're going to hold that for a
Okay,
second.
hold it. Thanks. I think once we talk to you, it'll refresh your memory about the buttons.
You fully understand them.
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. And that would likely include mental health treatment so that you can stay on the right path and be able to be successful. Is that your understanding?
Yes, ma'am.
Also, that there would be a dismissal in clause number 25 DCCR 0170 as part of that. Is that correct?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, Ms. Bailey, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And that'll just give me more information about you, your case, and that way also everything will be in place for you to have anything that you need as soon as you start your probation with regard to mental health or anything else, okay?
Yes, ma'am.
And so we'll see you back at sentencing.
Okay.
Okay, good. Mr. Rojas, you have Bethany Batten.
Yes, hello.
Bethany Batten.
Oh, she's, okay,
Transported, yes, ma'am.
okay. We'll reset that. You have Relacia Mouton.
Those are rejections, Judge.
Relacia Mouton.
Morning.
Good morning.
Good morning again.
Good morning.
Uh,
Okay, it's nothing.
There's 5 cases. I can do. Are both of those
There's 2 states.
possession of controlled substance state jails and all the rest are second degrees? I can do it without filling that. Good morning, ma'am. Are you Relacia Mouton?
Yes, ma'am, it's your.
And Ms. Mouton, in cost number 25 DCCR 0907. Before we go forward, I'm going to take judicial notice of the court's file. It looks like there was an evaluation done by Dr. Capon last year with regard to competency, and that we received that report back in October, and Ms. Mouton was found competent to stand trial. Is there
Did this in January 20th.
the competency reports from October?
You found her competent January 20th. That's what my file reflects also, Judge.
Okay. Maybe we didn't get her back. I don't know why.
She didn't.
There's a lot of things there with.
Hold on.
I don't think she was ever taken anywhere.
No. So I don't know why. Anyway, found competent based on that report. There hasn't been any other reports that I know other than the Dr. Capon report from back in October. And so any other issues at this point with regard to competency?
No, you're not.
All right. So in cause number 25 DCCR 0907, Ms. Mouton, you're charged with the 2nd-degree felony offense of assault on a peace officer. And what that means is that if you go to trial and you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand? I need you to answer out loud for the record. Thank you. And then in cause number 25 DCCR 1466, you're also charged with assault on a peace officer. This one is from August 17th of 2024. The first one that I read out was actually from May 5th of 2025. So this second one, same thing, is a 2nd-degree felony. If you're found guilty, the range of punishments between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And in that case, that means that if you went to trial and you were found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand that?
Yes, ma'am.
And then in cause number 25 DCCR 1468, you're charged with assault on a peace officer. And this is from that same date of August 17th of 2024. Again, if you're found guilty by a jury, the same punishment range applies, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then the last case is 26 DCCR 0120. You're charged with possession of a controlled substance, a state jail felony from August 8th of 2024. And in that case, if you were found guilty, the range of punishments between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
I have here on the tablet plea bargain rejections that you've signed with Mr. Rojas that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 8-year term in prison and on all of those assault on a peace officer cases that would run at the same time concurrently. And then a 2-year sentence in the state jail prison on those two.
The offer was actually we would dismiss the state jails, Judge.
Okay, so there would be a dismissal in the 2 state jails with, I'm going to make that notation.
Because I just signed paperwork refusing 2 years with both of those.
You did. So obviously the bigger cases are the 8-year terms. So what the offer is, and so that we're all on the same page, it would be 8 years TDC on the 3 assault on a peace officer cases with dismissals in the 2 state jail cases. Does that change your mind?
No, ma'am.
Okay. So you have every right to reject.
Probation.
Hang on. So you have every right to reject those offers. I just need to make sure that you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty, and you understand all of that.
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set for trial. Ms. Mouton, listen. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am. I thought you was trying to make me keep him.
Well, it wouldn't be the worst thing because he's one of the best lawyers we
I
have.
understand.
So, Mr. Rojas, you're released. And Ms. Mouton will give you a new attorney. They should be out to see you very soon to begin preparation for trial. You can go back with the bailiff. Also, hold on, come back. Mr. Smith, do you anticipate there would be any reason for that offer to change?
Judge, I thought that was a very generous offer.
So I do want to make sure you understand that just getting a new lawyer doesn't mean things are going to change. The offer is what it is. And so there's not going to be any change just because there's a new lawyer.
I've seen the tapes and it's not enough on the tape to show that I deserve 8 years.
All right, but that'll be up to
trouble in 20 years.
That'll be up to a jury. That's what juries are for. You can go back with the bailiff.
Makes sense to me.
Mr. Kitchens is on his way over on the Wilbur.
Perfect. Thank you. She was like, oh, that was funny. Let's see, Mr. Parker. James Holmes and Mr. Parker are both in the back. That's fine. If they're working on something. Dang. That Miss Holmes. And then Lloyd. Okay. Mr. Parker, you have Lloyd Calhoun. Yeah.
Parker didn't have this thing yesterday. I said, you better do that because she won't let you plead. What is that? I think they just haven't said, you have to have the dashboard.
All kinds of new stuff's happened since he was up here, all the words that he's saying. Good morning, are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, will the judge.
And we're just going in the possession case, is that correct?
That's right.
Correct, Judge, but on the, with the prior enhancement counts to make this a third degree and just so to be candid with the court. In 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense. What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by felon, July 8th of 2019. And are all three of those prior convictions true?
Mm-hmm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later, right? And it looks like the agreement's for 5 years in prison with a dismissal in cause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you're serving time anywhere else or were anywhere else. Okay. So you'll get that credit. I'm going to, is it not printing? Okay. I'm going to hand you in just a minute a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So name it now.
You put in the holes.
Well, I think I probably printed it twice at least.
And this is, what I printed stuff for Pam a while ago.
Oh.
What I gave her wasn't all of it. Apparently ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay.
I printed one for me, several things for myself.
Well, I think it's something.
Okay. All right. Here you go. You can go back with the bailiff.
No. Yeah. I mean, ask them every time. You understand. I tell you everything you're going to say. You have any questions? You understand everything I've gone over to you?
I know.
They always got to say something. I guess he understood. He didn't understood.
That's true.
Pam.
Oh, she probably wants to file that.
will help that copy I gave us.
Mr. Parker, you've got Patrick Trahan, 2 cases.
Patrick Trahan.
Right here.
There's actually 3 cases, one of them being dismissed.
Thank you.
Judge, that was based on the fact that we just came back confident we're trying to dispose of that situation, that window.
So, which one's being dismissed?
The 9-6 would have been the 1-6.
1916. Okay. Good morning. Are you Patrick Trahan?
Yeah.
And, Mr. Trahan, I'm going to take judicial notice of the court's file in all of his cases. Mr. Trahan was evaluated for competency by Dr. Gapon. And we received that report dated March 2nd of 2026. The finding in that report is that Mr. Trahan is currently competent to stand trial. Any other evidence with regard to competency
No, Your Honor.
from the state? No. Then at this time, I am going to find that Mr. Trahan is competent to stand trial. Mr. Parker, will your client waive the formal reading of the indictment in each of the cases?
No, Your Honor.
And are we going on count 1 only? On the assault on a peace officer?
Yes, Your Honor. We may need to go on both on the stage.
Okay, hold on a second. Sorry. All right, Mr. Trahan, in cause number 25, DCCR 1917, the state's elected to proceed on count 1 only. It alleges you committed the 2nd-degree felony offense of assault on a peace officer, and that's from November 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then takes a minute for me to get it. And clause number 26, DCCR 0592, you're charged with the state jail felony offense of possession of a controlled substance from March 17th of 2025. And how do you plead to that charge?
Yeah.
Again, are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? Also, in that indictment, it alleges that you were previously convicted of the state jail felony offense of theft of copper, bronze, or aluminum, August 11th of 2014. And then after that was final, you were convicted of burglary of a building, a state jail felony, May 15th of 2015. And are those 2 prior convictions true?
Yes.
In each of your cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, I do.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Right.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Get caught up here. Right, so I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you entered your pleas of true also in the second case freely and voluntarily. Find again that you're mentally competent, that you understand the nature and the consequences of your pleas. And clause number 25, DCCR 1917, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in clause number 26, DCCR 0592, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find those 2 prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Those 2 cases will run concurrently, which means together at the same time. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a trial court admonishment, or the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, and I will sign that dismissal now in clause number 25, DCCR 1916. All right, you can go back with the bailiff. All right, let's see, Eric Tran.
More flash. I don't have anything. I just took comments without taking fire message. I played with everybody but you and Doug. And then one of the comments got reset, one was in conflict. So you want to, you guys safety, but I don't know, you gave me credit for time served on the reckless.
Yeah.
Are you going to miss it, or is he going to plead?
Oh.
It was training.
These are also.
Yeah, right. Okay.
I'll get them to do that. Is it set today? Do you know?
I don't know. They usually said it today, but
I'm asking.
Yeah.
I'm asking where it is. I'll go to that.
is it here? We got two. Yeah, it's here. And y'all see my misdemeanor. What do you want? What's your misdemeanor? Is it 2 to 3? You do. I mean.
Good morning, sir. Are you Eric Tran? And Mr. Parker, will your client waive the formal reading of the motion?
Here we are.
Mr. Tran, in clause number 22-40541, I have a motion to revoke your community supervision. It shows that you were placed on probation January 17th of 2023 for evading arrest or detention with the use of a vehicle, a 3rd-degree felony. And that was a 10-year term in prison that was probated for 5 years. Is that correct? Mm-hmm. The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of reckless driving November 28th of 2025 in Jefferson County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 10th of 2025 that tested positive for the byproducts of cocaine. And is that true or not true?
True.
And then count 3 alleges that you have failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for me to continue you on probation, but order that you enter and successfully complete the safety program. And then you would be back on probation and required to follow all of the rules and conditions. Is that your understanding?
Judge, that was the recommendation when I spoke with this officer, Judge.
Okay, thank you, Ms. Malfino. And it looks like also you would enter a plea on that reckless driving for the time that you've already
I
served.
think you can get your credits. We're probably going to dismiss it, Judge. I mean, it's,
He's got so much
Oh, okay.
credit that it would probably technically easier. to-
Yes, we're going to
Yeah,
resolve that
dismiss it,
today.
Let him go.
Okay, so then what I'm going to do, Mr. Tran, it sounds like everybody's wants to get you back on track, and that's what safety is for, so that you can have the tools necessary to be able to stay clean and do everything you're supposed to on probation. And so I'm going to follow the recommendation from probation and the district attorney's office. Find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke the probation, but I'm not going to. I am going to continue you on probation. I'm going to order that as a condition of that probation, you enter and successfully complete the safety program, and then follow all of the other rules and conditions of probation. If you do all of that, we should never see each other here again, and you'll be able to finish that probation or your time while you're out on probation. But you need to keep in mind, if you mess up again, you're going to be back here in court, and we're not going to be talking about the same type of thing. You'll end up going to prison. You've already agreed to a 10-year sentence.
Yes, ma'am.
Okay. Good luck to you, sir. You can go back with the bailiff.
Hey, do you want to, check my work?
See, Ms. Holmes, you have Edwinia Johnson.
Yes, Your Honor. It's a custom law construction. I think it's last one. I'll check this. Oh, well, thanks. I didn't do it.
They're for bonds, right? We're not, or she entered pleas on them, or just here for bond?
I did like that.
Thank you.
And I didn't, but there was a bond set on it. Has she been another one?
There's got 2 robberies, one you get 2 into, 3 into our business.
I've got one robbery.
Yes, one. It's. But that's somebody else.
So,
Yeah, that's not.
well, we'll get responsible for that because of the name.
And so the request for bond are on the 3 MTRPs, correct?
Yes, Your Honor.
Good morning. Are you Edwinia Johnson?
Yes, ma'am.
And Ms. Johnson's here, and cause numbers 24 DCCR 2151, 2152, 2153, and then there is also cause number 25 DCCR 1826. And the first 3 cases are all probation cases that Ms. Johnson is currently on, and there's been a motion to revoke filed in each of those. The underlying offenses are forgery, abandoning or endangering a child in the other 2, and then that new offense is for robbery. Ms. Holmes filed a motion asking for me to set bonds in those 3 underlying motion to revoke cases. She's on deferred, but I set it for a hearing based on that underlying offense. I want to know really what's going on before I figure out an amount or if I'm going to set bond. So Ms. Holmes, I'll let you go first. You're going to call your client for the purposes of
Yes, Your Honor.
Ms. Johnson, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may proceed.
Okay, you, Edwina Johnson?
Yes.
Okay, Ms. Johnson, how long have you been, in custody at the Jefferson County Jail?
It's in 8 days.
Okay, and you're in there because you understand that there were motions to revoke probation due to allegations that you violated probation, correct?
Yes, ma'am.
Now, the alleged offense of robbery is one of the underlying allegations. You're understanding of that, correct?
Yes, ma'am.
In which the offense date was not very long after you were placed on probation.
Yes, ma'am.
Okay, we've discussed that. While you have been in custody, we've talked about you trying to wanting to get back on track with probation, and while all of this is pending, correct?
Yes, ma'am.
Now, if the judge was to set a bond, where would you be residing? You don't have to give the exact address, but would it be in Beaumont?
It was in Port Beaumont.
Okay.
Either or.
Okay, and you have family who have obviously reached out to me who would be supportive of you to make sure that you come to any and all court proceedings and that you do whatever is necessary. And
Here's where the stakes become very real. Every answer matters because the judge is weighing more than just the crime. She's evaluating responsibility, remorse, and the likelihood of future behavior. One wrong move here could change everything.
that you understand that if you are given a bond, that there may be certain restrictive measures, such as GPS monitoring, things of that sort, placed upon.
Yes, ma'am.
Okay. And are you asking the court to set reasonable bonds in your cases so that you can hopefully be released and try to get back on track with probation? It doesn't seem that you got very far with starting probation because you hadn't been on it very long. Is that correct? Okay. And so you're asking for bonds to be set so that you can try to get back on track with that.
Yes, ma'am.
I'll pass the witness, Your Honor.
No questions.
All right, any other witnesses?
No, Your Honor.
Mr. Smith?
Judge, because they're deferreds, I believe that you have to set a bond. We would request those be fairly significant bonds. The underlying offense, even though it's not with strangers, it's people that she was living with. There was an argument, it turned violent. This defendant did not live there, but she was there. She gets in on it, holds her down while they take this other person's phone, ripped it right out of her hands. So this is 1 week after she went on probation in these 3 cases.
Last week.
Not yet.
And obviously she doesn't understand the significance of what is being held over her head. I don't know that I would offer to keep her on probation based on that without some kind of significant cognitive treatment so that she would understand how to make better decisions. But we would request those bonds, like I said, to be significant.
So probation started in all 3 of these cases, October 6th of 2025. And so probation's here. And ma'am, would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And so were you able to have any meetings with the defendant, Ms. Johnson?
Yes, ma'am. I met with her in October when she first got placed on probation, and then again in November. But when the offense occurred, she then reported to me when I met with her in November. And that kind of was alarming to me. And then also in November, she told me that she was in Houston. No, I'm sorry, I think that was December. She went to Houston without letting me know first. So that was also another concern. And so there may be some compliance issues with that.
Okay.
Imagine standing in court accused of aggravated robbery, one of the most serious felony offenses, and deciding to plead guilty without any sentencing agreement. That means placing your future entirely in the judge's hands,